Good morning, everybody.
Morning.
Morning, Mark.
Morning. Could I ask those who are taking part today to turn their cameras on, please, but keep their microphones off at the moment? Thank you. Right, I can only see the way that Teams is set up. I can only see a maximum of 9, I think. So, but whenever you speak, I think your face will pop up. But please do keep your cameras on. So, good morning, everyone. Just for those who weren't here yesterday, my name is Louise Gibbons, and I'm the inspector appointed to examine the North West Leicestershire Local Plan Partial Review. And this is the second day of the hearings. I'd just like to introduce Carmel Edwards. She's the programme officer and is your main point of contact. If you have any queries about today's event or other matters that you wish to raise, please do so through her via email. Thank you. I will come quickly on to those who are taking part. We did this yesterday, but it's helpful for me to go through people again, just because we have a couple of new faces who are attending today. So what I'll do is I'll just ask for confirmation of your name, organisation, and how you would like to be addressed as well. So I'll start with North West Leicestershire, please.
Ian Nelson, Planning Policy Team Manager at North West Leicestershire. Mr. Nelson will suffice.
Thank you.
Hugh Richards, Planning Barrister, advising North West Leicestershire.
Thank you.
Hi, I'm Rob Thornhill. I'm Joint Strategic Planning Manager for Leicester and Leicestershire.
Okay, thank you. For Leicester City Council, I think you need to, your microphone needs to go on. Is it Miss Gupta?
Sorry, yeah. Fabian DeCosta from Leicester City Council Planning Policy Team.
Okay, thank you. And is it Ms. Gupta?
It is, yes. Ripple Gupta from Senior Planning Officer, Leicester City Council. Sorry about the microphone.
No, that's fine. It's hard work getting used to all of this. We'll get there eventually. And then I'll move on to the Home Builders Federation.
Good morning, ma'am. Sue Green from the Home Builders Federation. Ms. Green.
Ms. Green. Okay, thank you. And for the Pegasus Group?
Yeah, good morning, madam. It's Gary Lees of Pegasus Group, acting for various clients. Thank you.
Okay, thank you. Davidson Developments.
Good morning, Mum. My name's Chloe French and I work for Bidwells, acting on behalf of Davidson's for their land interest in Ipstock.
Okay, thank you. And you are you a Ms, or Mrs?
Mrs, but
Mrs.
Chloe's fine. Thank you.
Thank you. And then for Gladman, please.
Good morning, Ma'am. Phil Bamford from Gladman Developments.
Thank you. And representing DJ and SC Smith.
David Pendle, Ma'am. Yep, representing DJ and SC Smith with interests at Castle Donington, and I'm from Marron's Planning.
Okay, thank you. Do I have anybody from Roscon today? No. Okay, thank you. And Gaisley.
Good morning, ma'am. It's Matthew Fox from Turley, representing Gaisley, now known as GLP. Mr. Fox or Matthew is fine.
Okay.
Thanks.
Thank you. Thank you, everybody. And there are a number of observers today watching the proceedings who are not taking part in the discussions. Could you please make sure that you keep your cameras and microphones off? Okay, thank you. So I'll just explain a little bit about the process. I'm not going to do the full opening, but generally I will lead the hearing sessions, introduce each topic, and ask specific questions of the participation. And for this examination, I am allowing participants to be visible at all times, except during breaks when cameras and microphones should be turned off. The reason why we do that is because if you don't, everybody can hear either what you're saying or see what you're doing. So it's important that you do. Microphone should only be turned on when you are speaking. Please use the raise hand facility in Teams to indicate your desire to say something. That did work well yesterday, so we'll continue to use that today. I will end the discussion on any topic when I have enough information. Each session should last no longer than an hour and a half, although I managed an hour yesterday before I needed a short break. It's quite hard concentrating on a screen with a number of people, so we may stick to the hour with breaks. And as I said, do remember to stay logged on, but turn your camera and microphone off during the breaks. You might have recognised that the sessions are actually being recorded. For those of you that were involved yesterday, that recording is already up on the website, and I want to thank the council for getting that up so quickly. Just in terms of documentation, it's not appropriate to show anything on the screen. All material produced should be on the examination website, and I think that includes some information that was sent to me on Monday, so that should be available. New documentation should only be submitted following specific agreement from me to do so during the hearings, and then that will have to be sent to Carmel via email to be put on the website for everyone to see. Just to remind people again, we won't be using the chat function in Teams. We don't need to use it. Any queries, again, just ask Carmel. So just briefly, in terms of the examination, to be sound, the local plan should be positively prepared, effective, justified and consistent with national policy. I need to consider whether it is sound, if not, why not, and what can be done to make it sound. Has anybody got any queries on the process today? No. Okay, thank you. In that case, then we'll turn quickly to the agenda. So today's agenda covers main issue 2, and that's whether the proposed changes to policy S1 are justified, effective and consistent with national policy. I have split today up into 2 sessions, and I think I would like to stick with that, even if it's only a fairly short session this morning. So the morning session will deal with questions 1 to 5, and then this afternoon we'll deal with question 6 onwards. So to start with, the first question related to policy S1, referring to the submission of a replacement local plan, but with the council having started on a substantive review of the local plan. So I just wanted to come to the council to explain, I think, the differences between the way it's been addressed and whether the policy S1 should actually refer to the substantive review. Mr. Nelson, would you be happy to cover that first, please?
Yes, thank you, Madam. Yeah, this is really, it is a reflection of where we are in terms of the review of the local plan that was required by policy S1. And once it became clear to us that we weren't going to be in a position to address what the previous inspector had asked us to do in policy S1, which was basically to deal with the issues of taking unmet need from elsewhere within the housing market area. And so it was apparent we weren't going to be able to do that, because at that point in time, and we're talking sort of spring, summer of last year, so 2019, we still did not have a quantified unmet need from Leicester City. And so we were then faced with a very challenging situation of, what do we do, particularly bearing in mind policy S1 had a very strongly worded deeming provision that if we did not submit within 2 years, then the plan was out of date. And as I said yesterday, and we've said in our statements, that's not something the council could countenance. So we had to make a choice about what we were going to do, and the approach we came up with was that we would concentrate just on policy S1, but at the same time work in parallel on a wider review, a substantive review, whatever you want to call it, but we would be working in parallel on that as well. And the reason for using the term substantive review in terms of things that we put out is it was to help really the public more than anything else, who aren't so involved in planning as obviously we are on a daily basis, just to understand that actually there are two different reviews taking place. Ultimately, though, the partial review coupled with the substantive review as processes will result in a replacement local plan. And that's why in the policy it talks about replacement local plan. That is then absolutely clear. It's going to replace what is the currently adopted local plan. And that was the logic behind using those terms. Per se, substantive review is a process. The outcome is replacement local plan.
Okay, just a couple of follow-up questions. When you submit the substantive review, will you call it the substantive review though? And in addition to that, will you have a new policy S1 so that the partial review will then be replaced itself?
Yes, probably. Okay. I mean, certainly in terms of what the plan will be, it will be the replacement local plan. And in terms of policy S1, I would envisage there'd be certainly something like that. It may not be policy S1, it might be something completely different, but yes.
But the majority of policy S1, I take it, would still, if it was to be a strategic policy, would cover matters like housing and employment requirements. Is that right to suggest that?
Yeah, there will need to be some policy or policies somewhere that set out what is the quantum of development that the plan is making provision for.
Okay, thank you. A number of people did comment on the wording, whether it should be a substantive review or replacement local plan. Did anybody want to add anything to that? I think Ms. Green, you referred to it not being clear exactly what was being said.
Yes, thank you, ma'am. Yes, I said that I didn't think it was explicitly clear, but in my reading of it, I had just assumed that the substantive review was the replacement local plan. I suppose, as Mr. Nelson says, over time it will perhaps become obvious that it is the replacement plan. Perhaps it could have been set out perhaps a little clearer, not necessarily in policy, but perhaps in the supporting text.
Yeah, and Mr. Fox, I think you also referred to it as well, didn't you, in terms of whether there should be some other information in relation to the substantive review.
Yes, Ma'am, that's correct. I think personally I find it quite confusing because we've got a partial review, then we've got a substantive review, and then there's a reference to a replacement local plan as well. I think I just found it quite confusing when I first looked at it. I appreciate what Mr. Nelson has just said about the substantive reviews, the process, and then the outcome will be the replacement local plan. I think it may be quite helpful for that to be sort of either weaved into the policy itself or in the explanatory text. And I think particularly as the local development scheme is referring to a substantive review, I think it would be a bit neater if that was the case.
Yeah, I mean, I think I agree with what Mr. Fox said. It's not entirely clear now whether that needs to be in the policy itself or in some form of supporting text. I suppose the communities may have got used to the two terms, but there's actually a third term being used in this plan, which is the replacement local plan. Could the council give some thought to some wording, I think in the supporting text, just to provide a bit of context as to why there is a difference, and I think just confirming the position eventually that although this is a substantive review, it will be a full replacement local plan. I think that just needs clarifying.
Yes,
Mr.
Madam,
Nelson.
yes, happy to certainly give that some consideration. I agree. I think if it is going to go in, it needs to be a supporting text rather than policy.
Okay, thank you. Did anybody else want to say anything in terms of just the terminology that has been used? No. Okay. Thank you. In that case, then we'll move on to questions 2 and question 3 as well, because there is a little bit of an overlap between these 2 questions. So the first question 2 relates to the change in circumstances since the adoption of the local plan, including the publication of the 2019 planning policy framework, and also my question relating to the consistency with the framework in terms of preparation and review of local plans, if policy S1 is to be retained in its current form. Mr. Lees brought up the matter of the Peel investment cases yesterday, and I would just like to come back to that. Thank you for getting those in. Has everybody seen them? They're now on the website. Okay, thank you. I think we discussed really the matter of the plan being out of date. Mr. Richards, would you be willing to explain from your perspective and go through the deemed out of date position as far as you see it?
Yes, Madam. You will know that in the NPPF there are 2 provisions whereby policies are deemed to be out of date. The first concerns the lack of a 5-year supply, and the second concerns the application of the housing delivery test. But otherwise, whether or not policies are out of date, in particular for the purposes of paragraph 11D, the grant permission unless element of the presumption in favour of sustainable development, whether those most important policies are out of date is a matter of planning judgment. And what the Peel Investments case does, first of all, is to confirm that. Secondly, Peel Investments confirms that remarks of Lord Carnworth in the Suffolk Coastal Cheshire East Supreme Court litigation, the name you give it depends on who your client was. Lord Carnworth said that, or appeared to indicate, that if a plan was past its sell-by date, as he put it, or its end date, so an old plan running from 96 to 2015, and there we are sitting in, or here we are sitting in 2020. Lord Carnworth appeared to suggest that such a plan might be, or the policies in such a plan might be out of date because the end date of the plan had been passed. What the Court of Appeal does in Peel Investments is to say, no, if the NPPF had had that intention, then it would have said so. In other words, what the Court of Appeal has said is, you shouldn't assume a plan is out of date unless there is a very clear intention. And the problem with a deeming provision in, although the point was not expressly addressed in Peel Investments, the problem with a general deeming provision in a plan is that is a clear intention. And what the Court of Appeal said in Peel Investments, and indeed Lord Carnwath said in Suffolk Coastal Cheshire East, was that some policies in a plan obviously persist beyond a end date of a plan. For example, local plans set greenbelt boundaries. If you have a plan that on its face says, in the event of a particular circumstance, this plan is deemed to be out of date, are you saying that greenbelt boundaries no longer apply? Because they are policies in the plan. So a general deeming provision is a very bad idea in planning terms, for reasons which we now understand, and therefore that's why we agree with people like Gladman's, who in their response and Pegasus in their response have said that such a general deeming provision is unfortunate. Now, this afternoon, we're going to get on to discuss what the consequences ought to be if the trigger, if the various triggers that might appear in policy S1 are missed, such as the agreement of a statement of common ground or the submission of a plan. We're going to discuss that this afternoon. But what's clear is that a general deeming provision that the whole plan should be out of date is not sound, not justified, and not effective. Does that help?
Yeah, it does. I mean, I'm just looking at the framework in paragraph 16, which refers to containing policies that are clearly written and unambiguous. So it's evident that the decision maker knows how to react to development proposals. My reading of policy S1 as it's drafted is that someone is likely to think that the plan should be deemed out of date and the tilted balance would apply. You know, I think have there, I mean, Mr. Nelson, have there been any appeal decisions that have grappled with this, or any decisions within?
Not within North West Leicestershire, no.
Okay.
No, and there wouldn't have been, madam, because the deeming provision only applied if the council missed the date for submitting a review, and as you know, the council avoided that situation arising by submitting the partial review. Okay. It didn't. The deeming provision didn't say that the partial review had to be found sound. I mean, if you, for example, were to find that the partial review was not sound, or that the duty to cooperate had not been passed, or any other legal requirement, actually the requirement of policy S1 had drafted would still have been met, because a plan was submitted.
Okay, thank you, Mr. Lees.
Yeah, thank you, madam. I'm not going to get into a legal argument with the barrister, given I'm a planner and not a lawyer. But Mr. Richards is right. The Peel case didn't grapple with the actual issue that we're talking about here. And, you know, from my point of view, it's a situation whereby what is being said is clear, but you know, if you look at what the Peel, the appeal court said about Peel at the very end, there was that it does come down to matters of planning judgment. So I'm still kind of reading it that, you know, whether it says is deemed to be out of date, there's still going to be a planning judgment to be made in terms of whether that is actually the case. And obviously the reason, you would have to look at the reason for that statement being in place. And the reason for that statement being in place in policy S1 was a foreseen change in circumstance that was on the horizon when the policy was written, about accommodating Leicester's unmet need potentially, which hasn't happened. So, you know, from my view, an interpretation of that and applying reason and planning judgment would be that the policies, had the council not submitted a partial review, that the policies would still apply as though you were still past the end date of the plan. So that's my view on it, and also what we have here in terms of this particular partial review is a mechanism just to try and get over that. It isn't trying to fulfil the objective of what the policy was trying to say and what the inspector was intending when that plan was adopted. So just cut to the chase, the bottom line for me really in this whole situation is that you get, and my concern, if I can be clear, is that you will end up with a new plan, and therefore the obligations of reviewing a plan are potentially fulfilled by this process, which is very inconsequential in terms of a review, but is still a review, and you will have, you know, it's just a situation of whether you're going to get a new adopted plan now that will, you know, potentially give further time before the next plan is reviewed, notwithstanding the timetable. I'm just explaining the reasons why I'm deliberating this particular point, madam. So yeah. I should just sort of explain that I'm not making arguments for the sake of it. That's where my concern is.
So your main concern then really lies in whether the council won't now come forward with a substantive review, and that this would remain the position for some time to come. Is that your concern?
Yeah, I mean, at the moment, the council are pressing ahead with this, with a comprehensive review, which is great news. Their local development scheme and the evidence to this examination is setting out a good timetable for that. So it's all looking good at the moment, and it's all very rosy. And I'm personally very comfortable with that. It's just that if this happens and goes through, then new housing numbers come out, members get jittery, and obviously that process just gets pushed back potentially.
Yeah, I know. I don't know whether anybody wants to add to that, but I'm just thinking. I'm just wondering what if from what I can tell from most of the representations, there seems to be general support for the policies in the plan, obviously given considerations about paragraph 11D. So, and I understand the reasons why the plan being deemed out of date was introduced by the inspector, but I just wondered what teeth it has anyway. If most of you think, well, the policies in the plan are still relevant to some extent anyway. So I'm just trying to grapple with that particular element. Does anybody want to say? Yeah, Mr. Richards.
Thank you, madam. Yes, I understand where Mr. Lees is coming from, and he's a very reasonable person in my long experience. But the problem is that on the face of the policy, for the public to read, for less scrupulous planning consultants than Mr. Lees to read, is this deeming provision. So that's the first thing. The second thing is that Mr. Lees is quite right. If there hadn't been that deeming provision there would have been no need for this partial review. And thirdly, if you are concerned, and I would understand the concern, and I confess it's not something that I've thought about since I have been advising the council in this matter. If there is a concern, for example, that there is a fear that the council might say hereafter, well, we did the partial review, that counts as, quote, a review for the purposes of the NPPF, and what councils may or may not be able to do within 5 years of a review, then you could make it very clear in your report, and B, the council could include some additional text to make it clear that this was not a substantive review for the relevant paragraphs of the NPPF, so that, for example, it wouldn't reset the clock for reviewing a local plan every 5 years, if that's the concern.
Okay, thank you. I'll come to Miss Green first and then come back to you, Mr. Lees.
Yes, ma'am. I mean, if we come back to the question, it says, is the approach justified? And my answer to that had been no. And that was on the basis that the partial review to change policy S1 is not the review that was envisaged by the inspector examining the local plan. And as participants in the previous examination back in 2016, this partial review is not the review that we were led to expect. And using the council's terminology of the substantive review, that was integral to the soundness of the plan. And without the commitment to doing a substantive review, the plan would not have been found sound. Well, it wouldn't have been found sound back in 2016, so it would have either been found unsound or withdrawn from examination. So the council was actually given a 3-year reprieve in which time to have an adopted plan in place. But by not undertaking the substantive review as set out in policy S1, we go back to the same position as in 2016, that the unmet housing and employment needs in the wider Leicester and Leicestershire housing market area undermine the soundness of the plan. And therefore, at that point, it was deemed, it was, I believe, put in by the inspector that if the council had failed to do that, then the plan should fall and it shouldn't just be rolled forward. Now, having said all that, the council, by having made a commitment to the review, even though that's now not been undertaken, did get itself into a position whereby it has an adopted plan. So I suppose that we now found ourselves in a situation where the council is now arguing that some of the policies in the plan that don't relate to housing and employment, which are still consistent with national policy, shouldn't be considered unsound, and therefore there are parts of the plan that shouldn't be deemed out of date. But on the other hand, relevant policies that do relate to housing and employment, in my opinion, should still be deemed out of date, and that the planning judgment on those policies should be removed, because these are the policies that wouldn't have been found sound if we hadn't had the review clause.
Okay, thank you. Has somebody got their? Oh no, that's fine. Thank you. Yeah, I'll come to others who have got their hands up. Miss Green, have you finished? If you could you put your hand down? Mr. Richards, do you still want to speak? If so, I'll come. You've still got your hand up, so I'll come back to you. I'll come to Mr. Lees then, and then Mr. Pendle.
Thank you, Madam. Yeah, what Mr. Richards just explained and offered by way of providing some explanation of the status of this, the implication of this partial review in the plan would be very helpful. I note in the council's position statement on matter 2, in their answer to question 6B, they say that the council needs to have the replacement local plan, the substantive review, in place by November 22. So the intention appears there, that is the case. The timetable for it is there, which is the case. So if that is explained and clarified within the plan itself, then from my point of view, that would satisfy my particular concerns with the implications of this partial review. I understand the concern to have an up-to-date plan, and those unscrupulous planning consultants out there who will lodge appeals saying it's out of date. I understand that, and the reason to try and cover off that position through this process. For me, it's about getting the new substantive review undertaken promptly. That's what I would like to see. So that would satisfy my concerns. Thank you.
Okay, thank you. Mr. Pendle.
Thank you, Ma'am. Just obviously listening to what Ms. Green and Mr. Lees have just said, and certainly got sympathy with the points that were just made. I suppose trying to separate out in my own mind issues of the implications of the policy and what that might mean for decision taking, and certainly comments about 5-year land supply and housing delivery test being the triggers for when a policy and a plan might be out of date, and separating that from how we prepare plans. And of course, Ms. Green's just mentioned the circumstances that led to policy S1 in its current form, and the web of writing strategies, and whether or not it's possible to sort of hermetically seal wording in a policy like policy S1 from the circumstances and therefore the remainder of the plan. And certainly at the start, as part of Mr. Nelson's delivery, he quite rightly said that the plan that would result from this partial review will be a replacement local plan. It will exist, cover to cover. Obviously, you'll know better than I, Para 31 NPPF talks about preparation and review of all policies should be underpinned by relevant and up-to-date evidence. And you've asked in your question whether or not it's justified, and that leads us neatly into tests of soundness. So in my mind, I just have a sort of question, I suppose, floating around how we hermetically seal S1 from other issues that are taking place for the purpose of trying to decide whether or not a plan is sound, given the circumstances that led to S1, as very well laid out by Inspector Sims in his report. And then second of all, this question which may lead us on to this afternoon and deeming provisions, but what happens when a plan is found, or certainly the most important policies for an application, should I say, are found to be out of date for the purpose of decision taking under Para 11D. So in my own mind, I'm not sure quite how much that advances us, but I'm just trying to separate out the two things, because we're probably, it feels to me as though we're sort of lumping everything in. And of course, there aren't any hard lines drawn around the NPPF in that sense, but just trying to separate out decision taking from a plan that may or may not be sound. Yeah,
thank you. I mean, that's I suppose that I have questions in my mind as well. I mean, from what I can tell from the appeal judgment as well, that there's no provision in the framework in terms of plans being out of date. It solely relates to policies. So it's if that's the case, then what is the effect of the wording of policy S1? And as a decision taker, I might read it as everything being out of date in the plan, but I don't know what purpose that achieves, and whether under the current circumstances it would be effective or justified. So yeah, I mean, obviously those are the question. That's why I'm asking these kind of questions. Mr. Richard or Mr. Nelson, who wanted to go first for the council?
Yes, I'll just go first, if I may, Madam. Dealing first with Ms. Green's point, and it's really linked back to paragraph 15 of our opening statement yesterday, where we're very clear that the proposed changes that we're making or suggesting should be made to policy S1 will not mean that in considering planning applications, a decision taker will inevitably conclude that the most important policies, be they housing or employment land policies, are up to date. If you remove the deeming provision, the decision taker still has to decide what the most important policies are and whether they're up to date. And if you take a housing application, it might be that a decision taker would decide that there was unmet need still to be met, and that therefore policies that restricted where housing might be built were not up to date. That would be open to the decision taker. On the other hand, if next week full planning permission is granted for 7,000 houses, either in Leicester or elsewhere in the HMA, so that it would appear as a matter of planning judgment there was no longer any unmet need, then a different set of planning judgments might arise. So if next week the government changes its standard method so that there is no longer an unmet need in Leicester, then yet a further set of planning judgments might arise. So I agree with Mr. Pendle when he says we've got to make sure that we don't try and exercise decision-taking judgments now, or try and anticipate all of the decision-taking judgments that might come up in the next 3 years until the substantive review is in place. We don't try and do that now. And the mistake, if it was a mistake, that we were all guilty of in the last local plan examination was perhaps not thinking through the consequences of having a general deeming provision. Paragraph 14 of the then framework was similarly worded, but not precisely the same words. But we're now all much more comfortable with exercising planning judgments as decision takers as to whether or not things are or are not up to date. We don't require to be spoon-fed and given an exhaustive list of when something might be considered to be out of date or not. And therefore, in the context of the current framework and the state of the current knowledge about unmet need within the HMA, and in the circumstances of the government, to use a technical planning term, tinkering with the method of assessing need, we think a general deeming provision is a bad idea, and that what ought to be enshrined in the plan is a commitment to the exercise of planning judgment. Thank you.
Okay, thank you. Mr. Nelson.
Yeah, I just wanted to pick up on a couple of points from, I think it was what Ms. Green said. Totally agree that what the partial review is not what was intended by policy S1. Certainly wasn't what the council intended to be doing. But as we've set out in our various statements, and particularly the topic paper, we are where we are largely for matters beyond the council's control, not least of which is the fact that we've only very recently had a quantum of clarification on the quantum of unmet need from Leicester City. As I say, it's not where the council wanted to be. I'm sure it's not where everybody else wanted to be, but it is what it is. But as we've said, the council was faced with almost a cliff edge situation where if it didn't submit, then as written, policy S1 is very crystal clear. I also then just wanted to pick up, I think it was on the point that I can't remember, it was Dave Pendle or Mr. Lees, but yeah, again, agree with what they were saying there as well. Thank you.
Okay, thank you. I did just want to come back on the suggested wording. Mr. Richards referred to potential for something to be added in as a modification relating to the status of the substantive review. I think, as well as explaining the difference, I think that would be helpful. Of course, we'll come on to the triggers, so it may well be that there's some wording in the policy, but certainly an explanation of the process. Mr. Nelson, it might just help briefly if you could just outline whereabouts you are in relation to the substantive review at the moment.
Okay, so where we are in the substantive review at the moment is obviously now that we've got, two things have happened in the last few months. Firstly, obviously, the city have been able to give us that quantum of unmet need, which is helpful. And as we heard yesterday, good progress is being made on the sustainability appraisal of options as to how that unmet need, both for housing and employment, will be redistributed. The employment need was only declared, I think, if I'm correct, in March time. Again, as we set out in the topic paper, one of the uncertainties was not just about unmet need from Leicester and how much, if any, of that would come to North West Leicestershire, but was also uncertainty around the housing requirements are derived from the standard method. And again, as we've set out quite a lot of detail in the topic paper, but essentially North West Leicestershire is one of those authorities that, using the 2014 household projections, the requirement is significantly less than that in the adopted plan. And this is part of the problem we were facing. It wasn't that we had one issue, we actually had two, we actually had three in terms of the uncertainty. Now, obviously, we've had the 2018 household projections. They came out in July. So that's very helpful. And then recently, we've obviously had then the government's consultation, which is still ongoing in terms of changes to the standard method. The household projections are very, very important, obviously, in terms of the standard method. And I think I'm right in saying that using what is still the current standard method, that gave us a requirement of 910 per annum. So a significant increase, but also, of course, under the standard method, as it currently stands, there is a cap, and the cap would come into play. And again, I think if I remember this correctly, the cap would apply at 670 dwellings or thereabout every year. So that gives us a bit more certainty. Then the government come along with changes to the standard method, and they are significant, not least of which is obviously doing away with the cap. And under the currently proposed method, our requirement goes up to 1,153. So nearly a threefold increase from the adopted local plan. That is certainly higher than we had anticipated. That is certainly higher than we had anticipated, and conscious of needing to ensure that in meeting any need that we are capable of doing that, we have commenced work to undertake a detailed housing capacity sort of type study, and we've also last week issued a further call for sites, because we want to make sure that we have covered off all eventualities in terms of the potential for future housing provision if we end up in a situation where the proposed standard method and the government's approach is the need that we have to provide for. So that 1,153, that is a significant increase. So where that leads us all is we've probably moved one step forward and one step back, I think, to some degree. Looking at the local development scheme, we had intended doing some consultation over the summer months, partly because of the impact of COVID, but also because of the still ongoing certainty. We haven't progressed to that. We will need to review the local development scheme again. I mean, it's something you're always keeping under review anyway, in view of changing circumstances. So, the way I see it is it's a jigsaw. You've got different pieces that all come together, create a picture. Actually, sometimes you can get a clearer idea of what that picture is going to be, even if you haven't got all the jigsaw pieces. And certainly getting the household projections The 2018 projections is a big step forward and helpful. We just need clarity now from government on what it is going to do on the standard method. Is it going to go with its proposals, or is it going to do something else? And at the end of the day, none of us know. I'm sure we've all seen the planning press and the various murmurings from the backbenchers in particular. So who knows? But for now, what we're planning on the basis of is that sort of 900-ish figure is a starting point, but always in the back of mind will be the higher figure.
Thank you. Does all this uncertainty put in jeopardy the November 2022 date that Mr. Lee's referred to?
It's going to be challenging. There's no doubt about that. Particularly if we do end up with that higher figure of 1,153 or thereabouts. Not least because we will need additional evidence. We have already commissioned some evidence looking at a number of potential strategic sites of sort of 2,500, 3,000 in part of the district, and that's looking at a fairly high level at the potential infrastructure implications. In fact, that work has been done.
Okay, so work is progressing. Okay, thank you. Mr. DeCosta first, and I'll come to you, Miss French. Sorry, Mrs. French.
Thank you, ma'am. Yeah, it was just clarity, really. We've made representation about the draft policy referring to the HEDNA. And Mr. Nelson quite rightly says that using the standard methodology, the statement of common ground refers or uses the standard methodology in terms of the figures, housing figures. I just wondered if that's it needs to be updated, the policy, or remove that reference to HEDNA removed to be consistent with what we're discussing as part of the statement of common ground, as per our suggestion.
Okay, thank you. Mr. Nelson, could you comment on that?
That potentially could open a whole can of worms. I mean, I need to have a look again exactly what the wording is, but the simple fact of the matter is the adopted local plan was based on the HEDNA. And again, this is part of the dilemma that the council was faced with. If we are going to start including reference to the standard method, then the outcome of that, certainly in terms of at the time we were submitting, was that we had a requirement which was much less than that in the adopted local plan. Obviously, things have moved on again with the publication of the 2018 household projections. So it just has that potential to, say, open a whole can of worms and widen out the review and get very, very messy. And that happens, that diverts us away then from the substantive review.
Okay, so you're suggesting that is probably not appropriate for the partial review. It's something that you would tackle through the substantive review. Mr. DeCosta.
Yeah, absolutely. What? Sorry,
yeah, I just wondered if that
whatever the standard method comes out with.
Yeah, I just wondered if that could be made clear somewhere, because I think otherwise it does appear confusing if we are still referring to, in effect, old evidence, whereas our discussions are based on the standard methodology. I just think it needs to be made clear.
So possibly, again, it's possibly a change to the text.
Yeah,
again, rather
just to make it clear, I think, yeah.
Okay, we'll have a look at that.
Yeah. Thank you.
So just to come back to potential changes to the text, then we've got so far wording to explain the differences between the substantive review, replacement local plan, clarifying that position, looking at some discussion about the timetable, but obviously that's a little bit more uncertain than the November 2022 date by the sounds of it, and just a reference to how housing figures might be determined. Mrs. French.
Hello, thank you. It might be covering old ground, but it strikes me that the reason for the inspector putting in policy S1 was because the housing figures were unknown. And it also strikes me that we are in exactly the same position. it's there's sort of a higher level of uncertainty because we've got the standard methodology. We know what the Leicester figures might be, but again, that might change completely. And it's comment really more than anything else that it doesn't feel like there's any progress at the moment in terms of what is being achieved and addressing those initial concerns for why policy S1 was put in the first place.
Okay, yeah, thank you. Mr. Lees.
Thank you, Madam. I have a lot of sympathy with Mr. Nelson. I wouldn't envy his position in terms of trying to get these plans sorted out with the issues that you've got to grapple with. And, you know, I do agree with what he says. We are where we are. How quickly from where we are now can we get a plan adopted that's going to be meaningful and really deal with the housing needs that we know that are out there? That's the important point here. I just want to pick up on the issue of the wording, because we are inserting wording to a plan that was based, well, really developed in, a few years ago now, and as Mr. DaCosta said, dealt with a different set of housing needs. So we do need to be careful. The other element we need to be careful about, of course, is obviously, what's happening with this white paper, and with the change of standard method and the transition arrangements for plan making that are proposed in the white paper. We've got, from when it is crystallised, 30 months to get a new plan in place, or 42 months if you have a plan adopted within the previous 3 years. So clearly we want to make sure that North West Leicestershire will be working to the 30-month time frame, regardless of what's said here, I guess. And events may overtake us, and whatever we say now in terms of timing, we just need to make sure there's not a conflict with what the white paper might be saying. So I just think we just need to be careful about that we don't, because of what happened last time with the way policy S1 was worded is where we are now, which isn't helpful at all. We don't want another complicated situation down the line, really.
Yeah, Mr. Nelson, did you want to respond to that? Your microphone's off.
Sorry about that. Not so much what Mr. Lees said, although thank you, Gary, for the sympathy. I don't envy me either. No, it's just to pick up on the point that Mrs. French was making in terms of lack of progress. Totally understand where she's coming from. It's as frustrating to us as it is to everybody else, but it is circumstances beyond our control. If we go back to the examination discussions in March 2017, I think it was, there was a reasonable expectation that that Leicester City, having declared an unmet need, would be in a position to be able to quantify that fairly shortly. For whatever reasons, that wasn't possible. That's not within our control. Equally, not within our control is the, shall we say, to use Mr. Richards' technical term of tinkering, not so much necessarily with policies, but with changes to the household projections and how they seem to be extremely volatile at the moment, meant that North West Leicestershire was in a position where it ended up under the standard method with a significantly reduced housing requirement. Now, I have no doubt whatsoever that had the council decided, as it could have, that the review would basically take the standard method of 379. If we had pushed that forward and gone to examination, most people who are present today, and probably others, would have been saying, no, that's totally unreasonable, it's not positive planning. And I have complete sympathy with that position. You only have to look across. We're not in the same situation as, say, our neighbours, Charnwood, where their housing requirement has remained consistent for a number of years, whereas ours is up and down. It doesn't help anybody, and I appreciate the frustration out there, and I share that, believe me. As to the council has had experience of not having an up-to-date plan in place. it does not want to be back there.
Okay, so at the moment there's still commitment to continue working on the substantive review. It's just that some things are up in the air, not least because of the white paper. Is that right? So you're still working on the review?
Oh, absolutely. I think the white paper is an issue in its own right. It's actually more the consultation on changes to the planning system that were issued at about the same time as the planning white paper, and the changes in particular to the standard method. I think in terms of the white paper, that's just a whole new ballgame, which we are giving some thoughts to about if that's where the government decide they want the planning system to go. How can we try and future-proof the substantive review? But no, work is definitely continuing on that.
Okay, thank you. And you said you might need to review the local development scheme. Is that something that's coming up shortly, or is it something that might be a little bit down the line?
It's something I certainly need to be giving some thought to once we've certainly got this examination out the way, and also sort of dealing with these current government consultations. So it'll be sooner rather than later, but we do need to be trying to get that back sort of on track, as it were.
Okay, thank you. I think we've covered the majority of things that I wanted to cover for questions 2 and 3. Did anybody else who hasn't contributed so far want to say anything? There were a number of parties here that did comment on the questions. I just wondered whether they wanted to add anything. No. Okay. In that case, then we'll move on to question 4, and this is really relates to Leicester having provided what was an initial indication of unmet need at that stage. We have discussed this to some extent already yesterday, but for those that weren't involved, it would just be helpful if Leicester could just explain their position again, and just set out some of the background to the publication of the consultation that came out. Was it this week? Started this week?
Yeah, it was on Monday, ma'am. Yeah.
Yeah.
Just by way of background, we were due to consult on our Regulation 18 draft plan back in March, just before the lockdown. So, hence the delay. So we, as you quite rightly pointed out, we've commenced consultation on Monday the 14th. Regulation 18, it's exactly the same plans that we were intending to go out with back in March. Since March, we have completed some other evidence, which is also on the website for comments. This does not inform this draft plan, and will inform the next stages along with any comments we receive on our draft plan. In terms of the figures, they're very much the same. We have a housing need of 1,712 a year, which amounts to 29,104 over the plan period. We are allocating 5 strategic sites and approximately 85 other sites for housing. But we have a shortfall of 7,742 houses, which we're discussing through the statement of common ground with other authorities. We've also got a sort of an unmet need of employment land of 23 hectares as well. So that's where we are at the moment. In terms of our timetable, that has obviously slipped as a result of this. So we're looking at sort of August next year in terms of our publication. If you just bear with me, I'll just grab that sort of timetable to clarify. The other thing I would sort of mention at this stage as well is that we have provided a trajectory in the back of the plan, and using our supply and sort of need, the actual unmet need doesn't kick in till 2930, which is I think it's quite key really in these discussions. So that's something that, as I said, is at the back of our plan as well. So the consultation will last for 12 weeks, will end in December.
Okay, thank you. And just coming back to, you say that the unmet need doesn't really kick in until 2029, 2030. Was that right?
Yeah, that's right. So the first 5 years, actually, we're providing more than our supply. And then 29-30, that's when the real unmet need kicks in. We've got around 835, minus 835. So that's when the unmet need will kicking up to then. We're okay, really.
And as Mr. Nelson explained in relation to North West Leicestershire's figures, do these have the potential to change through either projections or the standard method? Any changes in that respect?
Yeah, I think it's safe to say that these numbers will change for us. Not only through the consultation, but we've got to bear in mind sort of the white paper as well. So there may be changes along the line, and one thing I think we do need to bear in mind is that any statement of common ground needs to be flexible enough to adapt to those changes, and that's quite important. Take into account the comments on our Reg 18. Some sites might be taken out, some sites might be put back in. So, we've done a lot of evidence work to support the plan at this stage. We've done a lot of capacity work as well, both in the city centre and on our strategic and smaller sites. I think it's also worth mentioning at this stage is that we've had a sort of an independent past review of our capacity, which we agreed with the districts, just to satisfy the duty to cooperate in terms of the city's capacity, because it's obviously has implications for other authorities, and that's been completed and shared with the authorities.
Sorry, just to come back to you then, I think Mr. Nelson also mentioned it. So that was the planning advisory service in right. Assessment. Okay, so what was the object of that then? Was that just well, if you could explain that.
Yeah, I think given that the government strengthened the duty to cooperate test to help with our process, it was considered useful to work with the districts to commission an independent review of the city evidence based before we went out to consultation. So the key aim of that was to review the city's housing capacity and sort of look at sort of what work we've done to inform that capacity. So we commissioned intelligent plans and examinations, past commissioned that. And we welcome that sense check, because I think we wanted to be absolutely clear about how we've got to where we are. And if there were any issues with the way we've done things, then we could address those. I think in terms of the outcomes, one of the key things we need to do is update our SHELA, and that's what we're doing at the moment as a result of that bit of work.
Okay, so that's your housing and employment.
That's right. Yeah.
Land allocations work.
Yeah, that's right. Yeah.
Okay, thank you. Ms. Gupta, I did see you with your hand up earlier. Did you want to say anything?
Yes, thank you, ma'am. Mr. DeCosta has covered that particular issue. So thank you.
Okay, thank you. Mr. Richards.
You asked, Madam, a question about whether or not the numbers in the Reg 18 Leicester City Council draft plan were vulnerable to changes in circumstances, and the answer is yes. And we've done a rough and ready mathematical calculation. At the moment, the Reg 18 draft is predicated on a need of 1,712 dwellings a year. But the standard method consultation draft 2020 suggests, if you believe the plethora of consultants who've produced work on it, suggests that might drop to 1,119. That would, if that happened, that would mean that Leicester would be looking for 8,900 roughly fewer houses than is currently in the Reg 18 draft. And that would be sufficient to wipe out the unmet need. So the answer to your questions is yes, the Reg 18 draft of the Leicester City plan is vulnerable to changes in the standard method and government policy. And that may come out at the Reg 19 stage. Who knows?
Okay, thank you. I'll take Mr. Nelson, then Ms. Gupta, and then Mr. Pendle. So, Mr. Nelson, did you want to add to that?
It was actually just picking up on what Mr. Da Costa was saying in terms of the Planning Advisory Service, the advice, just from a district perspective, if you like. Part of the reason for seeking that piece of work and working jointly with the city is that the districts and boroughs needed the reassurance that the approach taken by the city was comprehensive, because obviously if they're being then asked to take some unmet need from a purely political point of view, never mind any sort of planning merits or otherwise, they're going to need to be that assurance that the city has done a thorough job. And that was the real reason from our perspective as why it was important to commission that piece of work.
Okay, and has that satisfied that need for reassurance then?
Yeah, it has.
Okay, thank you. Ms. Gupta.
Thank you, ma'am. Just in addition to what Mr. Richards has said, that yes, our plan at Reg 18 is vulnerable. He's pointed out rightly the current proposals. So if the current proposals do come in, our need will, yes, drop. But I'd just like to add the in-between change, if nothing happens with current proposals, if standard methodology remains as it is, then what we've proposed in the draft plan will change anyway, because according to the standard methodology, we've got to use the latest, we've got to calculate the housing need in the base year. So our housing needs study has already identified a very slight increase in our housing need, which is different from what's there in the draft plan. It's 29,104. If we stick to the standard methodology compliance, it becomes 29,478, and that's basically using the latest affordability data ratio and changing the base year. So yes, he's quite right. It is vulnerable to change, and if we forget about the new proposals in which it does get reduced, without that there is that slight increase as well. So just to make you aware. Thank you.
Okay, thank you. Mr. Pendle.
Thank you, Ma'am. Just the point about whether or not Leicester City's position may change as their plan makes its way through the statutory plan making process. Of course, you're not examining that plan, neither are we. Para 11B footnote 5, of course, directs us towards statements of common ground, and this point may have been covered yesterday, so forgive me if I'm going over old ground. Para 27, of course, talks about a statement of common ground or a number of statements of common ground. On Monday, of course, Leicester City published the joint position statement relating to Leicester's housing and employment land needs, and that signals the unmet need and then signals the potential for a statement of common ground that would then in fact deal with that, and no doubt we'll either come on to have a conversation about whether that's mechanisms, process or policy. But the point being, under Para 11B footnote 5, we have a statement of common ground in the form of the joint position statement, which signals unmet need. So from the point of view of the exam question here, which includes, is this plan positively prepared and does it take into account unmet need from neighbouring authorities, you're directed to look at that joint position statement and form a view, and then to form a view on whether or not this plan does or does not do what it should be doing. Which sort of brings me, I suppose, back, without wishing to sound like a broken record, to how do you hermetically seal a policy, a trigger policy like this, from the remainder of the plan that it was generated from?
Okay, thank you. Ms. French, sorry, Mrs. French, I keep saying Mrs.
Thank you, Inspector. I was just going to follow on actually from Mr. Pendle about looking back at question 4, is the Leicester City numbers helpful? Yes, most definitely. We now at least know a ballpark, and okay, the standard methodology is going to come in. It'll be there or thereabouts from what I've seen in Leicester City, but the other authorities within Leicester and Leicestershire are likely to go up. But looking at the joint position statement, I note in paragraph 3.1 they're suggesting that they sort of put the unmet need into context, which I think is quite helpful. And they suggest that the need is around 9%, which is great. They then go on in paragraph 3.6 to say that this reduces to around 4%, assuming everybody does what they're going to do and or what they say they're going to do in their local plans. Which I think that is really helpful, and I know that sort of only came out on Monday, but I think that that does also provide greater clarity to the numbers. I would question Oadby and Wigston perhaps whether they would be able to provide more, and also Charnwood Borough in their Reg 18 plan have said that they are unable to provide any additional housing. So I think we're starting, you know, as Mr. Nelson said, we're starting to piece together that jigsaw and see where things are going to fall, albeit we just don't know at the moment. Thank you.
Yeah, thank you. I think it would be helpful to come onto the joint position statement in a bit more detail this afternoon. So I would like to discuss that and its implication. I realise that that question that I asked on question 4 actually overlaps now that there's been the publication of that joint position statement. Mr. Lees.
Yeah, thank you, Madam. I think just in answer to the question, yes, it's helpful in terms of informing changes to policy S1. I know from what Mr. Thornhill said yesterday that progress is now being made on agreeing, if you like, redistribution as a result of what's published. I hear the PAS Commission work in terms of testing that for the comfort of the districts, but of course I don't want to be a pessimist, but obviously that plan's got to be examined, and the inspector or inspectors examining that plan have got to be satisfied on its deliverability. So I think there are still some question marks over that number that will need to go through the examination process before that is necessarily precisely defined. And I think from my point of view, it's worth, you know, we need to crack on. We've got a number now at long last. We've been waiting for this number for a few years, and so I just think it does need to move forward productively now. But yeah, we have the standard methodology uncertainty, and we have the uncertainty of the Leicester City's examination as well. So, but it does need that flexibility within it to change quickly, and I think that's the issue there that we'll come on to this afternoon, no doubt.
Yeah, that's my intention. Mr. Nelson and then Mr. DaCosta.
Yeah, it's just to pick up on the point that Mr. Lee's just been making, and just to say that in terms of the sustainability appraisal work that is taking place, it isn't just looking at that figure of 7,742. It is looking at scenarios both above and below that, so that and you know, to be honest with you, the reason for that is so that if circumstances do change, we as authorities don't have to get back into doing another statement of common ground, because that will take time and will no doubt be painful as well. So we are trying to cover that off through the sustainability appraisal work.
Okay, thank you. Mr. DaCosta.
Yeah, very much the same as Mr. Nelson, but just to, I mentioned yesterday that the city have produced, you know, a lot of evidence after discussions with the districts about the capacity. We've got past to review that. These are all online now, in particular our evidence in relation to capacity within the city centre. But you know, just to bear in mind what Mr. Nelson said about flexibility as well. These numbers are going to change, we think. So the statement of common ground does need to have that flexibility to adapt to those changes. Thank you.
Okay, thank you. Thank you. Okay, we will move on to the discussion of the statement of common ground, the wider statement of common ground, also the trigger statement of common ground that I mentioned yesterday, and also the joint position statement. So I think all of those we'll discuss in detail this afternoon. It is my intention to just hold off and have that session this afternoon. In that case, anybody want to make any further points on question 4? I suspect we will come back to it again this afternoon. Okay, and then question 5 was really about whether I think the general thrust of my question was whether any other changes need to be made to other policies within the local plan in terms of consequential changes. Mr. Nelson, you've referred to potential changes, but you're suggesting those are just minor modifications. Is that correct?
Yes, that is correct. It was just when we had the opportunity, I suppose, to just look in a bit more detail that we did see there was a potential for a conflict. So yeah, we've identified those 2 minor modifications. Obviously, this morning we've been talking about some other possible changes to the text, and whilst I've been talking, I've been having a look at the local plan and thinking about where that might go, and it may well be something that goes fairly early on the plan to explain to somebody coming fresh to this that there was the original local plan, then there was the partial review, and what will happen thereafter. That might be the easiest place to try and put something in, but obviously we'll give more thought to that.
Yes, please, if you could. Yeah. Anybody else wanted to comment on that? A couple of participants here did comment on other changes potentially. Ms. Green, I think you're actually saying that other policies didn't need changing anyway, but you also referred to the strategic growth plan. I just wonder whether we might be best off covering that this afternoon as well.
Yes, ma'am. I think that will come into the discussion about when we talk about the triggers statement of common ground. I think that some of the other local plans in their trigger mechanisms refer to the strategic growth plan, but I think we'll probably cover that this afternoon.
Okay, thank you. Does anybody else want to raise any points? No. Any other matters they wish to raise on anything that's been discussed this morning? No. Okay. I will stick to the timetable today, so we're programmed for this afternoon. I realise it's a very long lunch, but I'm sure people won't mind that. So sometimes prefer it when we have a nice long lunch. But we will return at 2 o'clock and we'll resume the discussion on the statement of common ground and the triggers and other matters relating to question 6 onwards. Anybody have any objections to that? No. Okay. All right. Thank you. Well, I shall leave. I shall hang up and I shall see you all again at 2 o'clock this afternoon. Thank you for everybody taking part this morning. Thank you.
Thank you.